Thank you. Saqib, I'm sure we all know why we are here today. A fantastic skeleton has been drawn by Saqib. Without further things to do, I would like to move on to the panelists. But before we proceed, I would like to frame a question for my Lord, Mr. Justice Zubayer Rahman Chowdhury. The question is this. We have seen from Saqib's presentation, and we already know from our practice background, that Instruments Act and the Chowdhury Adalat Ain both of them are perceived to be unfair from the perspective of the issuer of the check and also from the perspective of the borrower, in the sense that both the laws tend to go in favor of the receiver of the check and also in favor of the banks and financial institutions. So the idea which is enshrined in the Constitution as our fundamental rights is that everyone is to be treated equally, everyone has equal footing, and law should be equal to everyone. So my question to my Lord, Mr. Justice Zubayer Rahman Chowdhury, I would like you to come here and elaborate on this. Do you think these two laws, which are very much in operation, are actually unconstitutional? Mr. Justice Zubayer Rahman Chowdhury.
Bismillahirrahmanirrahim. Assalamu alaikum to all the audience. At the very outset, let me express my admiration, and to borrow a quote from Sir Roger Moore, I'm speechless with admiration about the entire event. I'm very impressed, I'm taken aback, and I'm also very happy with the outcome, the enthusiasm that has been shown, demonstrated by the participants. I've been in the first session, which was equally interesting. I only wish that sessions should have been longer. Maybe the organizers will take a note of that. Now, coming back to the questions in hand. Firstly, in my position, and I'm now, I'm presently presiding over a constitutional bench, a writ bench. So, in my capacity, it would be very difficult, other than through a judgment, to make an observation or pass an opinion whether a law is unconstitutional or not. Whatever my personal view or opinion may be, it has to be reflected through a judgment. I personally feel that it is time that such an application should come before the court, which I think has still not come, and given the opportunity, the answers will be given. But my view is that that certainly both the laws, the Chowdhury Adalat Ain and the Negotiating Instrument Act, both have got certain loopholes which sometimes act to the detriment of the borrower and is sometimes used as a leverage by the borrower to delay and defer, and in some cases to make a way out not to pay the loan. But basically, I think that if you look at the Chowdhury Adalat Ain, which is 3, if you seriously analyze the law and the applications that has the outcome from the Chowdhury Adalat Code, it wouldn't take a very wise man to conclude that the Chowdhury Adalat Ain has not been successful or has not achieved the success which the government intended to achieve through the Ain. For example, and I'm just told that up to last year, the total outstanding loan is 80,000 crore or above. And I think this, the outstanding loan default culture, as we call it now, has been increasing with every succeeding year. And I must say that the policymakers, the banks, and certainly the borrowers have played a very active part in seeing that the figures go higher. I mean, you know, normally the indicators would be the growth and all that, but in our country, in our case, the indicators which go up are usually the negative factors, like the amount of defaulters, the amount of, you know, non-compliance, and all those negative aspects. So, looking from that perspective, looking at the staggering figure of 80,000 crore, which is now outstanding, at least we can say, from a common man's perspective, that the Authority Adalat Ain has not been very successful. And I think it's time for the policymakers to think about redrafting the law, make it more effective, and certainly should make it borrower friendly, not defaulter friendly. There is a difference in my mind between a borrower and a defaulter. So we must always take that human approach. I personally feel that 60% of law is common sense, is common approach. But when we go into the nitty-gritties, we tend to forget that at the end of the day, it's a common man's life which we are dealing. You see, it's not, I have presented over capital punishment benches, I mean, criminal appeals where the sentence is death. And it's not always that the person who's accused of a crime under section 302 of the penal code and, he's sentenced to death. There's always some other kind of death, like a civil death. When a man mortgages his property and obtains a loan, and for whatever reasons, in not all cases, there can be some very genuine reason, he fails to repay the loan. What happens? The bank just goes to the Authority Adalat, then the mortgage property, usually his homestead, is put in auction, and the other interesting but very alarming part is that I have found, I'll cite an example. In one case where I found a person had borrowed a loan. Let me share this example so it will illustrate the position that is now prevailing. A gentleman with very little education, but my respect is a very genuine borrower from somewhere out of Dhaka, borrowed Dhaka 2 lakhs. This was way back in 1990. If you recall, I think most of you were probably too young to recall, we had a very devastating flood in 1990. So much so that our international airport was shut for 7 days. Now, he could not repay. So, finally the bank filed a suit sometime in mid-90s for a sum of 5 lakhs. They have the right to do so, they have fine. But finally, what happened is, he had 2 properties, 10 kata plot in Mohakhali and a 7 kata plot in Uttara. Now, and this is from the records I'm sharing with you from the records. The bank auctioned both the properties, gave a tender and auctioned both the properties for us, and this auction was held in 2012. They auctioned both the properties for a sum of under 50 lakhs. And still, they made another further claim of some 40 lakhs and odd, that the interest had gone up to 80 lakhs. Now, by no stretch of imagination can we accept that a 10 kata property in Mohakhali and a 7 kata property land in Uttara, and that also in 2010 or 12, could be sold for only 50 lakhs. Now, what does that speak of? And last but not least, they had a warrant issued against him. That's when the gentleman came before the court. So this is the other side of the coin. So we have to keep in mind that at the end of the borrower is a person, is a man, is a family man having families. Sometimes taking a loan can be to the benefit of his business, but at times it can destroy the family, it can destroy reputation, his career. So we have to always keep a human approach. And that is where I think the law needs to be modified, the law needs to be redrafted, and it should be a borrower-friendly, but not a defaulter-friendly law. Thank you.
Fantastic. I think Mr. Justice Zubayer Chowdhury kind of summed it up. The law needs reform. It must be borrower-friendly, but not defaulter-friendly. And I'm sure there is plenty that the Law Commission can work on, and we can still debate on it, how we can make it much more borrower-friendly, as well as bank-friendly. It has to be, we cannot take sides. Law cannot take sides. It has to be doing justice. So that is what we need to look forward to. Now moving on, taking from there, where Mr. Justice Zubayer just left us, I would like to now call upon Mr. Ahsanul Karim, head of the Chamber of Law Valley. Again, he can talk on the entire topic, but my specific question to Mr. Ahsanul Karim is, from the perspective of the borrower who feels that he has been unjustly dealt with, is there, or do you think there is enough protection in the current law, that is Orthorin Adalat Ain or the Negotiable Instruments Act, and I include within this legal framework the constitutional jurisdiction, the writ jurisdiction that borrowers or borrowers' lawyers often resort to? Mr. Ahsanul Karim.
Ladies and gentlemen, good afternoon. This is a vital question. The one very important question was advanced to Mr. Justice Zubayer Chowdhury. Whether Orthorin Adalat and Act and the Negotiable Instrument Act are unconstitutional, or there is any unconstitutionality in these two acts. In fact, both the certain provisions of both the acts were challenged. The virus were challenged in the Commission, later on it was placed before that division. And in both the circumstances, the court held that neither of the acts were unconstitutional. This is unconstitutional. The act may not be unconstitutional, but it's harsh. Orthorin Adalat is certainly a harsh. As Mr. Justice Chowdhury has pointed out, a very peculiar situation which most of the borrowers are facing day to day. Eventually, if default is made in this country, default may occur at any time, because there are many factors which may play, by reason of which a businessman profit may be lessened or may not earn as expected, or such circumstances. There may be natural calamity, there may be political situations, political scenarios, which may result into a business to ruin in a very short time. And this may happen, and it happens in most of the circumstances in which the very good businessman also suffers a loss. Eventually, a businessman suffers and his property is put in auction. A property which worth about 100 crore taka is sold 50 lakh taka. This cannot be allowed. There are the witness of this law. Maybe these laws are not out of violence of the Constitution. This law may be good in point of constitutionality, but this law is a very harsh law in borrower's point of view. And why the default culture occurs in this country? Who does this? The mediocre businessman? No. The biggest businessmen are responsible for that. The banks are responsible for that, although many of the officers there, but their hands are tied. The banks officers are just instrumental to the board of directors. To my knowledge, as I represent, I am legal advisor of many of the banks, it is my personal knowledge how the board of directors influence the management, the bank officials to pay loan to various borrowers or to the Benabi borrowers, where the board of directors are directly involved. And in those cases, in those loans, neither good securities are there, nor there are good people against whom eventually, if loan is enforced or suit is filed, judgment is procured, bank ultimately does get good result in recovering the money. And in most of the circumstances, the board of directors are responsible for that. Not only in public sector banks, but also in private sector banks. And one of the most recent trend is that certain groups have emerged to take over the bank, the management of the bank. The banks are scared, the management are scared, the good businessmen who made good their investment in the banks are scared. They don't know when their money or their position may be grabbed by certain quarters with the help of government machineries as well as the central bank. In many circumstances, the bank management has been grabbed in daylight, where the state machinery is helped. And this in fact has contributed much in making these banks defaulters. Now, the questions which was advanced to me in borrower's point of view, whether this law is, what weakness this law has. This law has many weaknesses in borrower's point of view. One of the points that has been raised by Mr. Justice Zubayer is one fundamental question, and that has been dealt with by appellate division very aptly, I should say, because whatever be the valuation of the property, the appellate division has taken a view that they will not allow this property to be sold. Rather, approach has been made by the apex court to bank that the borrower will certainly refund back the money, and in lieu of that, within a certain period of time, the bank has to redeem this property. This has what the law. So, despite there is provisions under section 33.7 of certificate, bank takes the property in their own name, or bank certain other individuals, the apex court has taken a view that they will not let the bank to take this property by way of certification, or by way of registering this property in their own name, or by way of selling this property to a third party. Provided, however, the borrower, under certain circumstances, within certain stipulated time, is capable of returning back the money to the bank. So this is a relief to the bank, though the provision applies otherwise. There are many other provisions like summons. Even there is weakness in serving the summons. In most of the circumstances, the borrower do not get summons because there is provision of substituted service. What is the substituted service? The court of Adalat, instead of serving the notice to individual borrowers, issues the summons to certain papers, and the papers are not well circulated. Therefore, it's not possible for the borrowers to know that there has been a case. If it comes to their knowledge, they can go to the court and contest the proceeding. However, many a times they don't have this opportunity of contesting the case, and in most of the times the cases are adjudicated ex parte. So this is a very unfortunate event in borrower's point of view. Again, selling of the property under section 12, giving only 15 days time, which is very inadequate time. So when there is default, there may be default. And bank also has the right to recover the money. But there must be some provisions which may also help the borrower to pay the money, whether in one go or installments, and to get its property, to get their property back. And many of the circumstances I have also seen many times that although the borrowers approach the bank to pay at one time with request to waive certain amount of interest, the bank always denies, or the bank depends on Bangladesh Bank, where Bangladesh has nothing to do. It's a bank-to-bank affair, it's a bank-to-client's affair, and bank can do, but bank hardly exercises such thing to give relief to the borrowers. And so far Bangladesh Bank is concerned, Bangladesh Bank never interferes into this. Bangladesh Bank has no time to see these affairs, and therefore the good and the good borrowers, who are genuine borrowers, they suffer. And so far the big borrowers are concerned, see, Mr. Mahabub has pointed out certain facts that 80,000 crores are now this amount of money has not yet been realized by various banks, especially the government-owned banks. And this money cannot be procured very easily because banks are also not interested in getting this property back, because although there are huge number of defaults, but these banks, the government-owned banks, never files any cases against them, not taken any steps to realize this money. So I conclude hoping for the best that there must be, as pointed out by Mr. Justice Chowdhury, that there is the Ordering of the Law and other acts urgently requires amendments. I also suggest that there should be certain amendments so that equally this may be beneficial to the bank as well as the borrowers. Thank you.
Thank you very much, Mr. Ahsanul Karim. Again, echoing with Mr. Justice Zubayer Rahman, he's also advocating on behalf of an amendment to these laws in order to make it equal and justifiable and to do justice to both the quarters, borrowers as well as the banks. Thank you very much for your insight. We'll get back to you again, sir. But now let us hear from the bank's perspective. We have been hearing from the Honorable Judge, now a practitioner of the Supreme Court, advocating on behalf of the rights of the borrowers and the flaws and loopholes in the laws. Yes, but there's always the other side of the coin. There's always this other side of the story. And that is the reason why we are here together, all of us here. So let us hear from the banker, from the managing director of a leading bank of the country, Mr. Rahel Ahmed, MD and CEO, Prime Bank Limited. My question to Rahel Bhai is this, if you may please enlighten us. When we look at Bangladesh as an emerging tiger, as a growing economy, as making a mark in the world picture, we are growing towards mid-income, we are already mid-income country, we're going towards a developed nation in times to come, where we are seeking foreign investment, so much. The overall economy of the country is very important. And when we look at the overall economy of a country, the atmosphere, whether it is business friendly, from the investor point of view and also from in a general point of view, the role of banks and financial institutions are extremely important. And if, as the statistics suggest, if we have more than 80,000 crores non-performing loans, and if we have about 11% of the entire loan book as non-performing loans, then as the MD and CEO of a top bank of the country, what is your input? What is your insight? How do you look at it, Mr. Rahel Ahmed?
Thank you. First of all, I feel extremely privileged to be present today amongst all these luminaries of the legal world of Bangladesh. Thank you very much for inviting me over. First, what I want to add, statements already made. It may sound to be kind of adding a bit of fuel to what we have been discussing. The figure which has been quoted, 80,000 crore, 11%, mind you, is only the non-performing loan, excluding the rescheduled loans and the write-off figures. So if, from a banker's perspective, if you ask me what the real problem is, or how big the hole is bigger than 11%. So it could be, arbitrarily speaking, it could be somewhere close to 20%, as people say, or even more than that. So if we add back the rescheduled loan amounts as well as the write-off amounts, it may be much more than 80,000 crore. It could be another 25,000 crore. So we have a big problem in hand, no doubt about that. On the other side, at the same time, the economy which you are referring to, economy has been progressing pretty steadily over the last decade or so. We have broken the barrier of 6.5%. We have gone into 7%, above 7% growth rate now. There's no doubt that the resilience of the private sector, to be more prominent, has kind of fueled the growth over the period of time. The question, as one of the financial institution person in the country, I asked in many of the forums as an audience as well as as a participant, is that are we fit to grow further or not? I mean, I may be sounding a bit cynical in this at this point, but this is the right thing that we need to all have in mind. I mean, we have grown so far. Now we want to go to the next level. The question was that, if I'm not wrong, that are we ready to go for the next level or not? I mean, we all talk about something that are we fit to grow further? Now, are we fit to grow further? Yes, we are in certain areas, but the area which is hand in hand extremely instrumental for any country's growth is the financial sector. the banking or the financial sector. Are we fit to grow in that point or not? The answer I'll give is yes and no in the current state. Why yes and no? I mean, with all due respect to my previous speakers, obviously there are one sides of the stories as we say, but I personally don't believe that we should be generalizing and saying that, you know, it's the banks in connivance with some of the large groups and every, section of people, things happen. There are two kinds of default. Majorly speaking, there are two kinds of default. We all know, the business failure and willful default. If we look at the trend of the default history in Bangladesh's corporate world over the last 10 years, to be more specific, most of it has been willful default. And there has been a section of defaults, or a part of the defaults happened, especially in the Chittagong area, where the commodity traders or people who were in business in commodity, it was more to business failure, because mark to market there were, slump in the commodity prices and everything, so many of them had nothing to do but failing their business. Now, from banks' perspective, out of 57 scheduled banks, I wouldn't say that all 57 banks are doing directive lending. The 4 state-owned banks that we have, with full due respect to their management and everything, we all know what the reality is. So there is no point in discussing all over with that. And that is the reason for the last couple of years, even from the highest helm of the state, they have been directed not to lend any further. I mean, as we speak, there is a liquidity mismatch, as we call in the market. I personally don't call it a crisis or a liquidity strain. There is a mismatch of liquidity in the market, and we all know on a general level that there is not insufficient liquidity in the market. The liquidity is just in an imbalanced portion because the government banks or the state-owned banks are holding the majority of it, and they're not being able to lend. Whereas 70 to 80% of the private sector credit growth has been supported by the private commercial banks. And the private commercial banks are not having that much of liquidity as we speak. Now, out of the rest of the PCBs or the private commercial banks, there are a handful of them. There are instances where directive lending or the alleged incidents may have taken place. I don't deny from a banker's perspective on that, but that is not the general thing, I would say. Now, what is my, personally as a banker of the current market, what is my intention, or what is my request, or what is the thing that I want, is a fast, extremely fast resolution of the matter. Chowdhury is definitely was a very good step taken by the state or the legislative bodies and the relevant bodies to pace up the process. As the Honorable Justice and the law firm person has already mentioned, that there are possibly some weaknesses in that area. If you ask me, from the banking community, I can only tell you that all we want today is the money to be back, and as fast as possible. I am told, and I'm sure the fact on the ground is that Chowdhury Adalat is an effective, possibly an effective tool, but it is not properly resourced. There is a crisis of manpower or resources in there, and so many cases are pending that it is also humanly not possible for one person to, or limited number of resources to take care of those. So my request to the relevant bodies would always be, from the banking community, we have always been urging, when we are talking to different forums in central bank or different roundtable discussions, or even we meet relevant people, we keep telling that please man up those areas, because we need more resources there. Another point which has already been touched upon is the intervention, or as we call the REIT process and everything. That is one area which lingers the process for us. I myself, in my current role over last 3 years, I was away from the country for about 7-8 years. I got back and joined the current bank. I myself have experienced at least 10, 12 number of incidents, live incidents ongoing today, where we have full control, or, full legitimate judgment given by, the relevant bodies and everything, but to take control of or possession of the property to be sold off. On a daily basis, we are getting, writ petitions being filed by the borrower, by the defaulting borrower. So from our side, the only expectation is that to have a steady economic growth and have a fully functional financial institution market, the legal process has to be efficiently working, and that is because of the manpower crisis which we currently see is one of the major deterrents. Now, one last thing that I want to touch on is no matter where, not only the financial institution market, but for the country's economic growth and everything, the major most area that we need to touch on is the governance. The governance has to be in place. The right governance and the corporate governance in all the relevant areas has to be in place for the, the fitment to grow further as a country. Thank you.
Thank you very much, Mr. Ahmed. I think he summed up his fantastic elaboration in just 2 words at the end, which is good governance. So sweet, doesn't it? It is. Because good governance is what can kind of make anything which is not working to work. That is what we are looking forward to. We all know that we need good governance, but exercises like this, we are trying to find out the way towards good governance, where we need to go in order to find good governance. That is our goal and objective. But thank you very much. Now I move on to Mr. Affan Siddiqi, Country Head of Legal, Standard Chartered Bank. He will be giving his thoughts. We have already covered majority of the areas. Just for the sake of avoiding duplication, I have a specific question, Affan Bhai, to you. Being the Country Head of Standard Chartered Bank, which is a very big bank having huge operation in Bangladesh, we have been talking about Orthorin Adalatain, we have been talking about its flaws, we have been talking about Negotiable Instruments Act, and whether it is draconian, and whether High Court intervention is required, and whether there are areas where High Court should intervene. That much we already know. My question to you, Affan Bhai, is this. Being a practitioner in the field from the banking side, in order to protect the bank's money, in other words, public money, bank's money, there is no bank doesn't have money, it's the public money, the money of all the account holders. Do you think the current process that we have, the Orthorin Adalatain, which many say is biased towards banks, do you think it's enough for recovering those defaulted loans? 1. 2, do you think the intervention, which Rahel Bhai also mentioned, of the High Court Division, of the Supreme Court, the constitutional jurisdiction, on various provisions, at various stages, maybe at the beginning at Section 12, for the auction, and then when the auction proceeding is started for an interim, they make an interim application, and then application is rejected. Against that rejection order, you file another writ, takes another 2 years, and then at various stages, and eventually at execution stage, you get the property 33-7. Again, there is a writ filed, and then appellate division says, no, don't take the thing. So you see, we all talk about protecting rights, but where is the right of the banks? Where is the right of the banks? Where is the right where public's money, my money, your money, everyone's money is protected? Mr. Affan Siddiqi.
Thank you, Shafayat. Before starting, I would like to thank the organizers for organizing such a fantastic program. I'm really impressed so far. And before answering to your question, Shafayat, I would like to say a few words about the bank's roles and responsibility as well. Because I think when a borrower defaults, he or she may be a willful defaulter or may not be a willful defaulter, but there are some responsibilities on the part of the bank as well, so that that scenario doesn't arise, that he becomes a defaulter in the long run. So, as you know, whenever a borrower comes to the bank, he opens up an account, and that's the first step he puts into the bank. So bank's responsibility, I think what I'm saying is about any good bank should do is do a very good, we say in our banking words, KYC, know your client. So whenever a client comes to you, usually the relationship managers, they tend to have their targets. They want to take that client on board, in a hurried manner. So I think that's also a bit of weakness for a lot of banks. They don't do the background checks of the particular borrower or the potential client. Because if you have a background check, you will know the history of the client, and you will obviously try to avoid those clients who are basically habitual defaulters, who have been having these sort of records earlier. So I think that's a very important part on the part of the bank. And we also do customer due diligence. That's also a very important part of KYC. So if you do the due diligence properly, then in the long run, the chances of a borrower becoming a willful defaulter or a defaulter as such becomes much less. So I think that bit is also very important. And third point I would like to highlight here is that whenever you provide a loan to a borrower, usually there is a mortgage deed. Some properties are mortgaged in favor of the bank, and I think the weighting of the mortgage deed and the documents are extremely important. If you are very careful about the chain of title, and you are very confident that the mortgage that you have taken in favor of the bank is perfectly, okay, then the defaulting tendency of the borrower becomes much less, because he or she knows that whenever there is default, his property has been mortgaged, and those are good properties. So I think these points are very essential for banks to follow to ensure that the client that the bank has does not become a potential defaulter or a willful defaulter. And also you can go for early alerts, like the relationship manager should always follow the business of the client. If he sees that there is a some sort of difficulty the client is facing, they should alert the client that you see it's happening, so please pull up your socks. Otherwise, there can be a lot of issues going forward. So I think a bit of hand holding from the bank's part is also very important. Why I'm saying this? Because if the banks follow all these steps, then gradually the number of defaulters become less. However, having said that, there will always be some willful defaulters. We cannot avoid that, but we can avoid those defaulters who are not willful at all. So that's I think something we should do. Each bank should do that. In that process, the banking sector can really be really profit from that. And coming back to your point about the Authoring Other Laws and the NI Act, National Instrument Act, I've been a practicing lawyer for 10 years. I've also defended a lot of clients, defended borrowers as well. And now I'm also working for the bank. So I've seen both sides of the coin. What I've seen is that I fully agree with what Mr. Justice Zubayer has said, and all of us, we all agree as lawyers that everyone has right to file big petition if his or her fundamental right is breached. However, there should be a limit to that. Why I'm saying that? Because the defaulting borrowers are really abusing the process, the judicial process, and I mean taking advantage of the situation. They are depriving the government and the state to recover the money from these people. Let me give you an example, like what Shafayat was saying. Suppose a borrower defaults, and despite giving several reminders, legal notices, he doesn't pay back. Then you have some mortgage properties. You go for Section 12 of the Ahsanul Act, and you try to sell off their property in auction. So invariably, what happens? They go to the court and gets a rule nisi and a stay. And usually these days what's happening, the learning course, they're giving a limited timeline, like okay, the stay will be for a month. After that you cannot extend that. So that's quite okay. So one month, that's okay. After that, what happens? The rule is still there. So the rule has to be heard. It has to be discharged. Otherwise, you cannot proceed in the proceedings in the Ahsanul or anywhere else. So what happens is, so basically what happens when the stay is there, the rule is there. So rule has to be discharged. So you discharge the rule. So and then again the auction proceedings start. What happens? Again there is a repetition, for the second auction proceedings. So you see, this is a vicious circle that's going on. So ultimately you win the repetition, but because of the complexity of the cases, the volume of the cases in the high courts, it's very difficult. So that's basically what I'm saying. I also agree that there has to be some amendments with the Ahsanul Act as well as in the NI Act, and the issues have to be settled, so there is no more repetition with regards to the same sort of issues going on and on. Thank you.
Thank you, Affan bhai. I'm sorry to have, bringing you to an end maybe because of the time constraints. I would like to have some time for the audience. I'm sure the audience are kind of beaming with questions. We will take questions, but just a one-liner summary of what Affan bhai said was, yes, we need the constitutional jurisdiction must be there as the parent, as the guardian. They will be interfering, but too much interference from the guardians. I'm not saying that they are not entitled to interfere. Of course, they are entitled to interfere. But too much interference or too frequent interference may actually stall the flow and may actually be the strongest of the deterrent of a system to grow. Because we are saying that the Authority Adalat system, Authority Adalat Ain has not delivered because of all those flaws and all. That is correct. But having said that, too many interventions at every stages, as Affan bhai was saying. And a defaulter borrower would go again and again and again and again, and in the process take 10 years. And 10 years is a long time for recovering the money. So that is the point well made by Affan bhai. Now I will be taking questions from the audience. Well, volunteers, can you have enough microphones at the front, please? We'll be taking all the questions together and then the panels will answer.
Well, Brother Shafayat, before putting on a question, I will entail your statement. You said that this process of Ahsanul should let it grow. But when there is a flaw in the system, should that system grow? Should the system grow without correcting the flaws? So we must think two things. We must correct the flaws, and also when looking at the interest of the banks, the banks must find out a preventive procedure who to make their businessmen friends, who their board directors' friends should be, who should they lend the money, and what should be procedure. They must find out some safe way. Nothing is 100% safe, but they must find out some procedure, and the boards must be tightened up through legislation. And now, entailing the immaculate expression made by His Lordship Mr. Justice Zubayer Chowdhury, selling the property, the loan was 2 lakhs, it became 5 lakhs, then it was 50 lakhs, and 10 kata and 7 kata Uttara and Mohakali land were sold. So when a law gives a discretion to the bank, and the bank is using the discretion in a very inhuman and unreasonable, irrational manner, like one of the plots would have been put into auction. Why all? Now from my experience, before becoming a judge, then being a judge, then after becoming a practitioner, being a judge, my experience, I found several bank officers, bank managers, they use this sale before suit section to sell off the property to some of their big money friends and then have some share of the land. This shady deals. I've got several instances.
I'm sorry, we are running short of time.
My question,
for the question, please.
For the question,
Please.
this has to be told.
I'm sure we will be having many more sessions.
No. For the question, this has to be told.
Yes, please make the question.
So whether, my question is, whether can we all together, bank and we, suggest an amendment that the properties that is to be sold, whether an amendment can be made or a provision of law can be made in the Ahsanul Ain that the owner, the borrower has a chance, a time to sold out his property on his own initiative under the supervision of the bank, if required through a tripartite agreement or under the guardianship of the court, that they get a chance to sell. Let me sell my property.
Thank you.
I will sell my myself.
I've got
Whether we
your
can
question.
make this
Thank you, sir. Thank you. Is there anyone else? May I request, before I take any more questions, I'm sorry you'll be hating me for this, but please, we have to maintain time. At the back, Margu, I think, has raised his hand. Ragib bhai, I'm coming to you. What was the front bench delay?
Just a quick question.
Please go for it.
My question is basically, the exclusive jurisdiction of Ahsanul Adalat, the recovery of loan. Do you think it has been a success, or do you think that exclusive jurisdiction needs to be changed? Rather, like alternative dispute should be included for recovery of loan.
Thank you. Thank you very much. So this is it's an ideal question. One-liner question. We have the panelists to answer. Please. Next one. Anyone else? There, Ragib bhai, I'll come to you. Okay. Please introduce yourself and make the question.
My name is Farhan Mohammed Awa. I'm a lecturer to yourself, and I have a very short question, and that is, as we speak about recent developments, I read an article in Dhaka Tribune that says that trading Bitcoin and other forms of cryptocurrencies, which is very relevant in the context of 2018, is punishable by 12 years, which was by a Bangladesh Bank circular. So my question to the panel and everyone here is whether we should regulate Bitcoin or whether what should we do with digital currencies and cryptocurrencies that are going on and how it affects the modern banking country.
Thank you. A very fantastic question and very relevant question. I'll come back to Ragib bhai. Yes, at the front. We'll take one more question if you have, please.
Good afternoon, ladies and gentlemen. There is one allegation or accusation that the High Court division is lingering the process of recovering the loan. So here, what I have understood is that any defense or any issue of the borrower should be adjudicated before the trial court. So the practice is that the trial court, as you have said, it's the same issue. In brief, I can say that you have taken loan, so you'll have to pay it back. So they don't adjudicate any issue, any defense, any business failure, or any extenuating circumstance. They just pass the degree. My particular question before the panelists is that for the borrower to raise the defense or any issue of the borrower, if they want to file appeal before the High Court division, they will have to pay 50% of the decretal amount. So, is it an obstacle for the borrower to raise his defense or adjudicate the matter? Thank you.
Thank you. Yes, last question, but only 10 seconds. Please. We have to get to the answers as well.
Hi, I'm Galit. My question is, will the panel agree that there is the lack of corporate governance in our banking system plays a pivotal role in the current banking crisis? For example, দেখা গেছে যে জমি মর্গেজ দিচ্ছে কাগজে কলমে কিন্তু আসলে কোনো এখানে জমি নাই. So how can we make the directors accountable to it? Should there be an independent body, or do you think Bangladesh Bank is enough to monitor these policies of the private banks? Thank you.
Thank you very much. I think the time is up. I've just been given this time over, sir. That means I should leave the stage. But may I request for 5 minutes from the organizers, because we have to get the answers. We have quite a few questions. Let me sum it up. Suggestion is whether the borrower can sell the property without an auction. Say, for example, if he has a buyer of his choice with the bank. That's one. Second thing is exclusive jurisdiction of the recovery of loan of the authority courts. Should it be given to ADR, for example, an arbitration? Although we have mediation process, but the question is some other jurisdictions, just to ease out the congestion. The next thing is about digital currencies, how we should look at digital currencies, considering the future growth. The world is moving that way. And then came authority court appeals are 50% of the decretal amount has to be deposited. That is a hindrance, whether that kind of nullifies the right of appeal. And last one, a very good one, is the lack of corporate governance. Should there be some stricter laws on the directors so that they can be actually made accountable for their decisions? Panelists, I'll leave it to you.
So for the first question is concerned, whether there can be, although in the absence of the act, whether there can be voluntary and tripartite agreement, the mortgage property can be sold. Often this practice is restricted by many banks, although there is no provision. It is a practice. Of course, if there is provision, it can be resorted to more aptly. But in the absence of law, any law, it has become a practice in banking sector that banks allow such things. So far ADR is concerned, ADR is mandatory now. ADR is mandatory because so far I have gone to the court of Mr. Justice Chowdhury. He personally emphasizes that the mediation, as has been enacted in the Act, has to be first resorted to, and this is compulsory, and no further. There shall be nothing can be done by the Affan Act before completing this procedure of mediation. So this has become a mandatory provision, and this is being practiced. Of 50%, this 50% provision of law was challenged before Appellate Division, but Appellate Division has given the verdict that this is not under virus. However, this is certainly a harsh provision. In the absence of such harsh provision, the borrowers could have gone to the High Court Division or any other court as maybe to redress their grievances. But unfortunately, this provision is not there. By reason of this harsh provision, the borrowers cannot have the privilege of filing appeal. I think this provision has to be abolished. Directors. The directors are the sole reason of this. I should say, one of the main reasons of this big default culture, and there should be specific provision that directors should be restrained from interfering with this kind of loans.
I mean, on this corporate governance thing that you mentioned, I mean, definitely I totally agree with you, but I just want to add what he just said. I mean, it's not only the directors who are always responsible. I mean, there are things which happens because directors approve a loan which are being presented by the bank officers as well. So me being a bank officer, I take full responsibility that if I'm presenting something in connivance or willfully something disguising the facts, the director is not responsible because he sees the papers on. So not necessarily that always the directors are at fault, and not necessarily it's always the bank officers that are at fault. So there is a balance that we have to have.
Okay, we'll have some final comments from Mr. Justice Zubayer.
Once again, Assalamu alaikum. It's very difficult for me to restrain myself from answering certain questions, but as I said at the outset, my position makes it difficult for me to give certain answers. But I can and I will make some observations in my individual capacity, not as a judge of the Supreme Court, but as an individual of the country and a taxpayer of the country, if I may add. Now, the one of the aspects, because this is the seminar or this session is with regard to banking. So I think I shall not be out of context to dwell on one particular aspect, and that is the aspect of default loans and defaulters. Now, with that, I think is connected the issue of directorships. And of late, there has been some amendment where, particularly family directorships, where the number of directors from one particular family has been increased from 2 to 4. Now, I have no problems with that. It's the absolute prerogative of the government, and I repeat, it's the absolute prerogative of the government to set policy decisions. And that is a policy decision vis-a-vis the financial sector. So the courts have nothing to do with it. I personally have no problem with that. But where I find it very objectionable is, and to this I take serious exception, is that we are allowing by our acts and omissions, and certainly by introducing laws to allow this default culture to grow. We are not allowing the business sector, the economy to grow. I think we are allowing the defaulters to grow. And this is exemplified by the figures that we have shown, that since, although the Orthorin Adalat Ain has been in force for well over 15 years now, it's the same age as, I have the same age as the Orthorin Adalat, vis-a-vis my tenure in the bench, 15 years. But look at the figures. Has it succeeded in bringing down the figures? The answer is no. Now, there should be some measures where, because every right has corresponding duties and liabilities. A person has a right to obtain a loan. That's fine. That's guaranteed in the Constitution. But those rights, what they do is they exercise their rights, but they forget their responsibility, their duty. If you have obtained the loan, it is your duty. It's your solemn duty to repay the loan. That's it. Nothing more, nothing less. Yes, you may have some difficulty in the business, as the bankers have said. There can be some willful defaults, there can be some defaults due to business, there can be some reschedulements. But one cannot be allowed to default time and again, and to obtain loan from several banks. I think that there should be some law where there is no, as I said, there is no issue with a person, with a family having even 2, 4 or even 10 members in one bank. But that should be confined to only one bank, or maybe 2. And the directors must be held accountable to repay for the outstanding loan. There must be a nexus between the directors of a bank and their duty, responsibility to repay the loan. At the end of the day, as one of the panelists said, the money belongs not to the directors of the bank, not to the officials of the bank, with due respect, but to borrowers like you and me, who are here and who are taxpayers. People having honest earning and putting their money in the bank. That is the money with which the bank is doing their business. So I don't think the banks or the defaulters have any right to go scot-free. So there should be some checks and balance whereby the defaulters are made accountable to repay their loans. And yes, I've been hearing that every time the blame is put on the courts, that the courts are. But if the law is that we only apply the law, we interpret the law, we don't frame the law. It's for the policymakers, for the parliamentarians, for the lawmakers to frame such law, we will apply it. Let me finish by just narrating a story. And I said narrate this story, I think everyone here is Bangladeshi, so I Bangla bolchi. Eta ami onek bochor age ami eta ekta potrika, I cannot resist the temptation of sharing the story. It's a real story. এটা সম্ভবত আজকে থেকে 20 বছর আগে বিক্রম বলে একটা পত্রিকায় আমি পড়েছি, একটা সত্যি ঘটনা। এক ভদ্রলোক, একজন রিটায়ার্ড আর্মি ব্রিগেডিয়ার, উনি সংসদ ভবনের ওখানে মর্নিং ওয়াক করে হাঁটছেন। দেখলেন একটা 25-26 বছরের ছেলে খুব তাড়াতাড়ি হেঁটে আসছে, তার হাতে তার স্যান্ডেলটা, লুঙ্গি পরা, শার্ট পরা। এসে ওই ভদ্রলোককে জিজ্ঞেস করলেন, ওই রিটায়ার্ড ব্রিগেডিয়ার সাহেবকে, যে গাবতলী কোথায়, আমি গাবতলী বাস স্ট্যান্ডে যাবো। তো উনি একটু দাঁড়িয়ে, এবং ছেলেটা হাঁপাচ্ছিল, খুব তাড়াতাড়ি হেঁটে এসেছে। তো ব্রিগেডিয়ার সাহেব বললেন যে গাবতলী বাস স্ট্যান্ড এইদিকে, উনি দেখিয়ে দিলেন। তো বললেন, তুমি এখানে তো বাসে চলে যাও, তুমি এত তাড়াহুড়ো করে যাচ্ছ কেন? উত্তরে সে বলল যে গত বছর আমার বাবা চাষ করার জন্য 5,000 টাকার একটা লোন নিয়েছিল ইউপি চেয়ারম্যানের কাছ থেকে। সেই লোনটা শোধ করার শেষ তারিখ হচ্ছে আগামীকাল। আমি গত 1 বছর ঢাকায় রিক্সা চালিয়ে, আমি পুরনো ঢাকায় রিক্সা চালিয়েছি, আমি রিক্সা চালিয়ে এই 5,000 টাকা গতকালকে আমার জমা হয়েছে। আমি আজকে সকালে রওনা দিয়েছি। তুমি বললেন তুমি এখান থেকে একটা বাস দিয়ে গাবতলী চলে যাও। উত্তরে বললো আমার বাসে যাওয়ার টাকা আমার কাছে নেই, আমি হেঁটে যাব, এবং এত দূর হাঁটলে স্যান্ডেলটা ক্ষয় হয়ে যাবে, সেজন্য স্যান্ডেলটা হাতে নিয়ে আমি এখন গাবতলী যাচ্ছি। ওই রিক্সা চালক সে ওনাকে ধন্যবাদ দিয়ে হেঁটে চলে গেল। ব্রিগেডিয়ার সাহেব তার দিকে তাকিয়ে থেকে উনি মন্তব্য করেন, গর্বের সেটা একটা ঘটনা যে আমাদের দেশে যারা ব্যাংক থেকে টাকা ধার নেয় তাদের যদি এই সাধারণ একটা রিক্সাওয়ালার যে দায়িত্ববোধ এর 1/10 যদি থাকতো, আজকে আমাদের দেশে এই অবস্থা হবে না। I salute that rickshawa. I salute that rickshawa. And let me also say that I don't have any respect for the borrowers who borrow money from the poor people of the country, from the banks. This money is of the poor people, and go around flaunting their wealth. They should be ashamed. And I don't mince my words, and I stand by what I say. Give me a chance. May Allah take me. Keep giving us. Thank you.
Thank you very much, Mr. Justice. I think there is not much to say, and we are already above time, but thank you very much, audience. You have been wonderful, and there's not much to say. I'm sure Think Legal is a platform. It is there. It is just the beginning, but not the end. Let us go along together. The destination doesn't matter. Journey comes. Thank you.